independence that our Constitution guarantees and to enable judges to adjudicate fearlessly. For Section 47 to function as this safety valve, as it was intended to, it must be interpreted broadly, we say, not narrowly. Thirdly, Justices, we say we must interpret the provision contextually and sensibly, and in a way that, if possible, does not produce irrational or anomalous outcomes. If the Section 47 protections evaporate the moment a judge retires, or if they do not apply where a judge is performing a statutory function, like chairing a judicial commission of inquiry, or simply because the letters NO are cited after a judge's name, we say that this creates immediate anomalies. Let me consider the first illustration, which, as I understand the position, is the position of former President Mbeki. A sitting judge in active service is appointed by the President to chair a highly sensitive multi-year commission of inquiry. As I understand the argument, and certainly the pleaded argument, while that judge is in active service, he is covered by Section 47(1). But imagine that 2 years into the hearings, that judge reaches retirement age and retires, is discharged from active service, but continues to finalize the Commission's work. Does the protective shield of Section 47 evaporate overnight? We say that any interpretation that would allow that to happen should not be preferred. The second is the very example put to my learned friend acting on behalf of former President Zuma, where the question was whether a judge in active service is asked to chair a commission and then goes back into active service. Does Section 45 switch, Section 47(1) switch on and off, depending on whether the judge is at the time that the summons is issued or the notice of motion is served on him or her in the Commission or in the High Court? We say that that also creates anomalies, and it doesn't produce sensible outcomes. Thirdly, in response to my learned friend Mr. Manechi's argument for former President Mbeki, if it is so that there has to be a link between the proceedings out of which the notice of motion or the summons arises and the work that the judge is doing, we say that that would too defeat the object of the section, because it would simply allow vexatious claims to be instituted without that link, against a judge without that link. And these potential consequences would hang over the head of a sitting judge, almost like a sword of Damocles. The minute you stop being a judge, you can be sued and the protections will evaporate. And that will undoubtedly, we say, undermine the purpose of Section 47, which is to ensure that judges can adjudicate and fulfill their judicial functions without fear or favor. And I wish to respond briefly directly to the applicant's arguments to this court, where they rely on two primary but respectfully flawed arguments. These are, firstly, the argument that Section 47 does not apply to retired judges, and secondly, that it doesn't apply because Justice Khampepe was cited nomine officio. We say that the distinction between the personal citation of a judge and the nomine officio citation of a judge is a fiction. And that fiction is clearly exposed in this case. When one looks at former President Zuma's founding affidavit in the recusal application, he does not simply attack Justice Khampepe as an administrative decision maker. He launches direct and highly personalized attacks against her conduct, including as a sitting judge of this court. He attacks the judgments that she wrote that led to his committal. He accuses her of a travesty of justice, and he sensationally accuses her of criminal misconduct. Moreover, he seeks personal costs from her, not in any official capacity, but personally, de bonis proprius. And he makes claims of actual bias. This, we say, is precisely the kind of retaliatory litigation that Section 47 was designed to screen. Former President Mbeki, while somewhat more restrained, also bases his case to a large extent on Justice Khampepe's roles in the prosecuting authority and the TRC, and her conduct in the proceedings of the Commission itself. One cannot launch an attack on a judge's judicial record and conduct in proceedings and then hide behind the procedural technicality that she has cited nomine officio. Turning to the retired judge's argument, we point out that the text of Section 47(1) refers to any judge. It does not carve out an exception for retired judges, nor does it distinguish between functions performed as a judge sitting as a judge versus a judge sitting as a commissioner and the chair of a judicial inquiry. The only sensible purpose of interpretation of Section 47 is that a judge is a judge. A judge is appointed for life, and a retired judge remains a judge. When they chair a commission of inquiry appointed by the President, they remain bound by their judicial oath. They remain bound to uphold the honor and the dignity and the ethical constraints of their office, and so too must the protections of that office follow them against unfounded retaliatory attacks. And we commend to this court here the reasoning in Mantashi from paragraphs 18, where the court explained, and we endorse this, that the chairing of a commission of inquiry does fall squarely within what are ordinarily considered judicial functions. We say too that it was perfectly legitimate and indeed correct for the High Court majority, both in these proceedings and in proceedings before it dealing with this section, to take interpretative guidance from the use of the words judicial service in the Judge's Remuneration and Conditions of Employment Act. This is clear from the authority referred to by my learned friend itself, the Institute of Education case. It is no cardinal sin for the High Court to do so, as was suggested. Paragraph 37 of that judgment makes it clear that it is possible and indeed appropriate to refer to other legislation as an interpretative aid. And that is how it was used in this case. So we say respectfully that that ought to be the end of the proceedings. The text is clear, the purpose is clear, and the constitutional requirements of the section are best given effect to in a manner that indicates that consent was required, but it was not obtained. And for all of these reasons, the TRC Commission supports the High Court's majority decision. My next topic concerns why we say this court should decline to hear this review now. The applicants are asking this court to intervene in media res, in the middle of the unconcluded proceedings of the TRC Commission, and to review what is clearly an interlocutory refusal by the chairperson to recuse herself. Our law firmly discourages piecemeal litigation of this nature, and it strongly points against the interests of justice in this court hearing the application. A stay or interruption of incomplete proceedings to permit a review is not available as of right. The established common law rule, referred to as the Valhouse rule, dictates that a court will be exceptionally slow to interfere in the unconcluded proceedings of an inferior forum or tribunal unless a grave injustice or miscarriage of justice would result. And this court's judgments in Sakau and the Supreme Court of Appeals decision in Take and Save Trading make it clear that the principles apply with equal force to civil proceedings and indeed to challenges to recusal decisions. Now, the former presidents in their founding affidavits in the High Court did not plead or even attempt to meet this test, and did not plead any grave injustice or miscarriage of justice that would result. They now, before this court, attempt to bolster their case and argue that they do face a grave injustice. In essence, they say that they will be forced to submit to an allegedly unlawful process, and that this is a peril so great that this court must intervene now to stop it. Justices, the perils that the applicants point to are not exceptional at all. The same exact peril is present in every single case where a litigant contends that the proceedings against them are unlawful, or that the presiding officer is biased against them, or that the tribunal lacks jurisdiction. If the mere threat of having to participate in unlawful proceedings was enough to justify midstream intervention, then the Valhouse rule would cease to exist. Every disgruntled witness or accused person would immediately run to the court, the High Court, and then possibly this court, bringing the underlying inquiry to a halt. But there's a further point. There can be no grave injustice because there is no finality. Unlike a court of law, the Commission of Inquiry will determine no liability and establish no criminal culpability. It will make findings and recommendations, but these are not binding. The President may act on them, or he may not act on them. Because the outcomes carry no direct legal consequences, they cannot cause the applicants any irreversible prejudice. And this too, we say, renders the challenge to the recusal decision premature. Finally, under this heading, I note that the applicants are not left without a remedy, and this distinguishes this case from the Ramakatse case relied on by my learned friend for former President Zuma. The horse will not bolt if this court does not hand down judgment now, as it would have in that case. If the objections are dismissed, the proceedings will continue. The applicants will participate in the proceedings, and then in due course they may institute review proceedings at the conclusion of the Commission's work. They retain their full rights to do so and accept as much. We urge the court here to heed the oft-quoted warning of Lord Denning in Moran versus Lloyds, where he said, "We often find that a man who fears the worst turns around and accuses those who hold a preliminary inquiry of misconduct or unfairness or bias. He seeks to stop the impending charges against him. It is easy enough for him to make such an accusation. Once made, it has to be answered. And who knows, if he can stop the preliminary inquiry in its tracks, it may never start up again. To my mind, the law should not permit any such tactics." This litigation is, respectfully, precisely the dilatory stratagem Lord Denning warned against, and for these reasons, we submit that the review is premature, constitutes an impermissible midstream disruption of what is a vital truth-seeking process. And on this basis alone, the application should be dismissed. Justice, I'm going to turn to the substantive merits now. We say that even if the court were to look past the insurmountable jurisdictional bar of Section 47, and even if it were to permit a premature midstream review, the applications must nonetheless fail on their merits, because the applicants have failed in their recusal applications to dismiss the formidable presumption of judicial impartiality and have failed to meet the double reasonableness standard. And there's one aspect which I would like to deal with right at the outset of this, and this is a suggestion that it is common cause that Justice Khampepe was involved in all of the institutions that were read out to you, and that there was no substantive answer in relation to the functions that she fulfilled within those institutions. And I would like to point you, Justices, I won't take you there, and this is directly in response to an engagement that Justice Matopo had with my learned friend. If one looks at the answering affidavit in the High Court, from paragraph 78, it appears at case lines 001-1062. Mr. Semenya spends considerable time, more than 20 paragraphs, setting out exactly what the roles were that Justice Khampepe played during the period in question, and what that means for her ability and her objectiveness, the reasonable perception of her objectiveness in the TRC Commission. So that starts from paragraph 78. Then, at paragraph 243 of that same affidavit, case line 001-1100, there is a specific denial on oath that Justice Khampepe had any role in the HRIU, the Human Rights Investigation Unit, which was the unit that dealt with amnesty refusals and recommendations on prosecution. Justice Khampepe filed a confirmatory affidavit before the High Court, which appears at 011-518 of case lines, confirming those submissions to be correct. Then, in the recusal decision itself, Justice Khampepe again dealt with this issue. The allegation that she was called upon to meet there was that she had institutional responsibility, because she was in the NPA, there was institutional responsibility for the creation of prosecution policy. That was the case that she was called upon to meet. And you will see at paragraph 50 of the recusal judgment, 001-964, Justice Khampepe states that she has no knowledge of any prosecution policy that she is alleged to have had input into. She says, too, that the allegations are mere speculation and conjecture. So when one assesses whether a case has been made out to review the recusal decision, we say that these facts are important to bear in mind. We say two further things. First, that the case for recusal that the applicants mount is limited by the case on recusal that they instituted before Justice Khampepe herself. And Justices, you will have seen that the applicants have attempted to bolster their case for recusal by introducing new facts, such as the references to the Pepco 3 and the Masuku family. These were not facts which served before Justice Khampepe when she considered the recusal application. The second point is that, of course, this is a case which is limited to a review. It is not an appeal against the decision, and we say respectfully that there is a difference. My learned friend said, well, a review on recusal is basically the same as an appeal, and we say no, and that the applicants must be kept strictly within the four corners of a review. I'm going to address now the issue that has been raised by the court about whether the chairperson was correct to take the decision alone, and my learned friend for the Malata group will develop this further. But it's important for the TRC Commission to place this on record. We say that it was entirely correct, both for the application for recusal to be heard by the chairperson together with the other commissioners, and secondly, for the actual recusal decision to be taken by the chairperson alone. And we say that with reference to the SAFU decision specifically. As was pointed out to my learned friend by Justice Majid, the SAFU recusal judgment makes it plain that that was an application against the court, against each judge. And it was the whole court that was implicated. And it was for that reason that the judgment was issued by the court. But what paragraph 31 of SAFU makes clear is the statement that judges have the jurisdiction to determine the applications for their own recusal. In other words, a judge must determine whether there is merit against themselves, a factor which would normally give rise to procedural fairness problems. But what we also know is that where a judge whose impartiality is challenged sits with other judges or other commissioners or other decision makers, those other decision makers also need to satisfy themselves that there was not a ground for recusal. It's not that they need to make the recusal decision. It's that they need to be satisfied that they do not need to remove themselves from the process. And that too comes from the SAFU decision. So we say that when the SAFU decision is properly applied, there is simply no ground of review at all. that the chairperson took the decision alone. She was respectfully required to do so. I'm then going to deal with the institutional bias arguments. Both of the former presidents objected to Justice Khampepe chairing the TRC Commission on the basis that she served on the TRC Amnesty Committee from 1996 to 2001, and then she was Deputy Director of Public Prosecutions from September 1998 to December 1999. The applicants say that these roles, occupied nearly 30 years ago, establish sufficient institutional bias. Justices, we say that the recusal application had no merit. This court's judgment in Masuku makes it clear that the law does not suppose the possibility of bias. If it did, imagine the bedlam that would ensue. And the court continued at paragraph 68. What an applicant raising an apprehension of bias must prove is that there is some connection between the views, the opinions, or the experiences of a judicial officer and the subject matter they are to be seized with. So proving that there was that she was merely within the NPA, or that she merely served on the TRC Amnesty Committee, is not enough. Now, applying these established principles, the chairperson properly exercised the discretion that she had. And she found the following. First, she found that the applicants had ignored the temporal boundary because the Commission's terms of reference explicitly restrict its mandate to investigating whether there were any attempts or efforts made to stop investigations or prosecutions from the year 2003 onwards, 2 years after she had left the TRC committee, and 4 years after her tenure in the NPA had ended. She says she had no role beyond that, and what she did in her prior institutional roles will not be the subject of the work of the Commission. It will not establish whether there was executive interference after 2003. And secondly, on the subject matter boundary, former President Mbeki says the subject matter of the Commission arises from, that is the test he would prefer, from Justice Khampepe's association. But that is not so, because neither the TRC Commission nor the NPA investigated executive and political interference in the work of the NPA. And I have given you the references in the answering affidavit where that is clearly explained and set out. The question whether apartheid era crimes should be prosecuted or whether amnesty is correctly granted or not, now those, I submit, would give rise to the kinds of concerns. But whether there was executive interference many years down the track, we say would not. The next issue around the bias question and whether it was established relates to delay. One of the further factors that caused the chairperson to dismiss the recusal applications was the unreasonable delay in bringing them. And the facts of this delay are common cause. Justice Khampepe's appointment became public knowledge in May 2025. So did the terms of reference, the reference to executive interference. The applicants took no steps from this date. Both applicants received their Rule 3.3 notices in September or early October, but they bided their time. President Zuma, on the 14th of November, sought an extension in order that he could cooperate further with the Commission. And then Presidents Mbeki and Zuma launched their recusal applications in mid-December last year, 87 and 90 days, respectively, after their 3.3 notices were received. Now, I emphasize here that this was a commission that was only established for 12 months. So a delay of 3 months before a recusal application is launched amounts to a quarter of the time period that the Commission was given to investigate, hear witnesses, and come to its conclusion. This delay is unreasonable and violates the legal test that was set by this court in Burnett, which dictates that a litigant must raise an apprehension of bias at the earliest possible opportunity to avoid prejudice, and that a litigant cannot wait it out and only cry bias when they perceive an unfriendly decision has taken place. And we see here that the recusal letter was sent on the 3rd of December, when the decision on the Semenya recusal application had been issued the day before. It is clear the applicants were biding their time to see whether they would receive a favorable outcome, and when they did not, it was at that stage that the applications to recuse were launched. I will not deal, Justices, unless there are questions, with the allegations of actual bias that are launched by former President Zuma. I will simply note that former President Zuma, although claiming to be in possession of secret communications and evidence, failed to put any of these up either before Justice Khampepe in the recusal application, or before the High Court, or before this court, and that even the minority judgment there was forced to concede that there was not an iota of evidence. Thank you, Justices.
Thank you, Advocate Purifin-Jones. Questions?
Sorry, I just have one question for you. We were debating earlier on whether a decision by the head of court not to consent to the litigation may leave an applicant without a remedy. I wondered if you had a view on that, given that if one had a look at Paja, could it be argued that the decision to refuse would have external effect, and it also doesn't fall into any of the Paja exclusions? Paja excludes the functions of a judicial officer, but when the head of court decides not to grant consent, the head of court is not acting as a judicial officer. And then there would indeed be a remedy, a Paja review. I mean, the consequence is that there would have to be reasons for refusing. And so the party in that position, so that would be an effective mechanism to sift out, a court could sift out whether the head of court properly applied his or her mind to the facts, gave proper reasoned decision. And so a person in that position is not left without a remedy, as it were. Do you have any thoughts
Indeed,
on
Justice Collopin, I would simply suggest that that could indeed be inappropriate. I haven't looked at the definition of Paja, the exclusion of judicial functions, but to the extent that it can be argued that a head of court in those circumstances is not performing a judicial function that's excluded by Paja, then certainly that would be appropriate. But I want to make two further submissions, which is that the position is not nearly as dire as it seems, because what the authorities in Engelbrecht and Soller make clear is that the way the process works is that a letter is first sent to the head of the court. If the head of court is satisfied, then he'll grant the consent and nothing further will happen. If the head of court is not satisfied, what usually happens is that a formal application can be brought for consideration on affidavit, and reasons given, as you've suggested, which enables a decision to be assessed as to whether it was a reasonable one or not. And further, this is of course entirely a hypothetical decision, a hypothetical scenario, because in this case there was no application under 47.1 and there was no refusal. So we don't know what the outcome would have been, certainly not in this case.
What do you say about the argument that a recusal application brushes up, as it were, against the right of access to court in the right in Section 34, and that it's distinguishable from other civil proceedings that may seek damages or specific performance or located in contract or in delict. And therefore, the court is enjoined in terms of Section 39(2) to interpret legislation in a manner that is consistent with the values of the Constitution. And to that extent, one cannot simply conflate all civil proceedings under a single heading, but that there's an argument that an interpretation in civil proceedings that brush up, as it were, in the context of fairness. I mean, all proceedings could trigger Section 34, but it would be simplistic to suggest that the constitutional implications are felt equally. It may well be arguable that those that may implicate a fair trial, a fair hearing, may warrant separate treatment. And on that basis, there would be an obligation on the court at least to consider an interpretation of Section 47(1) that lends itself to aligning with those constitutional values, and that there's some merit in the argument that the applicants make, that 47 should be viewed within its proper context. And in that regard, this case would fall outside, as it were, of your general kind of litigation. You would probably say there's no merit to that, but I'd like to know what your reasons for that might be.
Certainly, Justice Colopin. And again, I've got three answers, if you'll bear with me. The first is that this question and the constitutionality of Section 47(1) and whether it was implicated, whether Section 34 implicated its interpretation and its constitutionality was considered in the solid decision. And it was found...
My question is not located on a constitutional misalignment. My question is located in an understanding of 39(2), which presupposes that the section, there's no constitutional attack on the section.
Yes.
But that notwithstanding, there still remains a duty on the court to interpret 39(2) in a manner that is constitutionally compliant.
Yes, Justice Colopin. And in Sola, the conclusion was that it did actually, the very fact that Section 49(2) is in place gives effect to the right of access to court, because the right of access to court is not unfettered. And when a head of court or the Chief Justice considers whether or not Section 47(1) bars or allows whether an application should be barred or allowed under Section 47, the test is good cause. And it is at that stage, I suggest, Justice Colopin, that the right of access to court under Section 34 comes into play. So it is not a question of interpretation such that one must include or exclude certain categories of civil cases. For the reasons that I suggested, I think that would give rise to anomalies, whereas the section is broadly framed. But when a head of court is deciding whether or not to grant the Section 47(1) application, that head of court must take into account the right of access to court and the nature of the case that's being brought. Is it a recusal case or is it a civil case?
And then, following from that, you would say, well, if one would have to look at each case on its merits, we don't get there, because
Certainly.
we don't have a 47(1) application.
Indeed, Justice Colopin.
Ms. Puddleton-Jones, the respondents seem to argue that Section 47 serves to safeguard judicial independence and public confidence in the judiciary. But this cuts both ways, doesn't it? While it's important to protect judicial officers from vexatious litigation and undue harassment, it's also important to ensure accountability and that no one is above the law. Would it not undermine public trust in judges and in commissions of inquiry if we were to extend judicial immunity beyond permissible borders or bounds?
Justice Turon, we'd say two things in response. The first is that Section 47(1) and the requirement to obtain consent is not an absolute bar. The test is good cause. And the person that is making the determination about whether good cause exists or not is not a lay person or a low person. It is a head of one of the high courts or one of the appeal or highest courts in South Africa. So there is no absolute bar. So to the extent that there is a limitation, it is a limited limitation, we say. And secondly, we say that we're not asking.
Before you go on to the second part of your answer, where does the good cause test come in Section 47?
Justice Turon, it comes from the authorities, and particularly the Engelbrecht and Soller judgments, which set out the mechanism in which the section operates and the requirement for good cause to be shown. And then we say that it's not an extension of the interpretation that we are asking for. We are asking for an interpretation which is in line with the language of the section, and is in line with the majority, the overwhelming majority, we say, of prior judgments which have found that it does apply in circumstances such as this.
Does this court, or must this court decide what a judge means in Section 47(1), or must this court, can this court just decide on whether a chairperson of a commission falls within the ambit of Section 47(1)?
Justice Serrano, it's something I gave consideration to. We, for the Commission, have run, if I can call it, a stronger case, which is to say a judge is a judge. A former judge who is chairing a commission remains a judge. A judge is a judge. The Halata group has run a slightly more nuanced argument, which says that this court doesn't need to get there. And with your permission, Justice Turon, I will leave that argument to my learned friend, Mr. Budlander, to address as to why he thinks that the nuanced argument is appropriate. But we have certainly run an argument to say that the meaning of the word is clear. A judge is a judge. Everybody knows what a judge means.
Yes, a judge is a judge, but you get a judge who's in active service, and you get a judge who has been discharged from active service. Surely there must be a distinction. What is that distinction? What does it mean to be in active service, and what does it mean to have been discharged from active service?
And then
I think it's a very simplistic way to look at it, to say a judge is a judge is a judge.
I accept that criticism, Justice Turon, in that in those circumstances, we would say that there are a number of ways that the courts have looked at this and where guidance can be got. And the first relates to, of course, what does service mean? And if we're talking about active service, but then we look at the Remuneration Act for judges and we find that a commission of inquiry, acting as a chairperson of a commission of inquiry, is a form of service. That would mean that even a retired judge is in active service.
Section 47 talk about service.
It doesn't, Justice Turon, but I was answering your question about whether there's a distinction in 47 about a judge in active service or not in active service. Section 47 doesn't deal with service or function. It simply talks about a judge.
Now, Section 7 of the Commissions Act, in terms of that section, a president can appoint a commission for the purpose of investigating a matter of public concern. There is no requirement that that commission must be headed by a judge. If someone is appointed other than a judge to head the commission, Section 47 would not apply to them. So why would a judge then be protected by Section 47 when a judge is appointed to a commission, and let's say an advocate is appointed to commission, they're performing the same function? It seems like an anomaly that one is protected by Section 47 and the other one is not, doing exactly the same function?
The answer here, we say, comes because of the incredibly special and protected role that judges fulfill in our constitutional democracy. They are afforded extra protections beyond.
That is when they are serving as a judge. Here, and I'm sorry to cut you short, I'm very mindful of time as well. Here, they're performing a function that a person who is not a judge could perform. And let's confine ourselves perhaps to a retired, especially a retired judge, which brings out that distinction more. So you get two people performing the same function. Because the one was in active service, they are now entitled to the protection of Section 47(1). But their counterpart, who is performing exactly the same function, is not.
It is because they carry with them their oath of office. They carry with them the honor and the integrity. They are called Justice Khampepe when they are referred to in the Commission. And with that honor and with that responsibility, we say under the Constitution,
That doesn't sound right, Ms. Clifton-Jones, because how council choose to refer to the chairperson, that special privileges must attach to them. So because they refer to the chairperson as justice, as opposed to chairperson and Mr. Chairperson or Mrs. Chairperson, as a sign of respect, that certain privileges given by law should attach then to that position.
I apologize if my example seemed overstated, Justice Turon. I was merely illustrating that because that person was appointed a judge, one of the highest honors, they carry their responsibilities and they carry their protections. That is what the wording says. We say that we may not like it. It may come with constitutional problems, as was illustrated earlier, but the section has not been challenged. The section must be faithfully interpreted.
So, if an advocate can perform, or any other person can perform the function as a member of the Commission or a chairperson of the Commission, then we can't say they're performing a judicial function. Would you agree with that?
Justice Khampepe, I'm just mindful of the Mantashe decision and the reasoning which led to the conclusion that it was a judicial function. It is certainly a function that can be performed by judges, but it is not a function that can only be performed by judges.
So where a non-judge or where advocate performs that function, it would not be a judicial function, would it?
They would not be performing.
So how does a non-judicial function become a judicial function simply because it's performed by a person who was at one stage in active service as a judge? See, this is one of the difficulties I have in this matter.
Justice Khampepe, it is, Justice Turon, I apologize. it is late and it is undoubtedly a...
That's strike two. First one go.
Yeah. It is undoubtedly a difficult matter, and it is difficult to know where to draw the lines. But we say that the legislature has chosen to draw particular lines, and that this court must interpret it in a way that makes sense and doesn't give rise to various anomalies. And yes, our interpretation would be that because of the status of the commissioner as a judge, they have more protections than an advocate.
So protections that are given in law, if I understand your argument, are conferred upon somebody simply because of their status or because of the way people refer to them in the commission as justice. That can't be right.
Justice Turon, we say that when you become a judge, you get certain privileges, one of which is that you cannot be frivolously sued without good cause. And that is a privilege that, like many of the other privileges of being a judge, extends right through a judge's life by virtue of the status and honor of the office of appointment. that is the case that we've made out, Justice Turon.
Another difficulty I have with the reference to the Superior Courts Act and the remuneration of judges is that a chair of a commission or a member of a commission is appointed in terms of the Commissions Act. They could be what we call creatures of statute. So surely they should derive their powers from the Commissions Act and from their appointment by the President. And that would apply to a judge or former judge who's appointed, and it would apply to a non-judge that's appointed. So this is another anomaly for me, that and let's use the example of an advocate because it springs to mind quicker. So a retired judge who's appointed gets powers from the Superior Courts Act, but an advocate appointed to the very same position does not get those powers.
Yes, Justice Turon, that is the position. And you say, should it all be regulated under the Commissions Act? Should there be equal powers for all? Perhaps so.
Isn't the only thing that's regulated by the Superior Courts Act is how the retired judge will be remunerated for the service that he or she is performing in the commission? Aren't we taking it too far to look for the powers of the judge and the powers they have in the commission by looking at service in the Superior Courts Act?
Justice, we say no, because the Judges Remuneration and Service Act does not only deal with remuneration, it also deals with the services that judges perform. That is clear from the Act itself. Remuneration and conditions of employment
Act. Of the Act do you rely on for that submission? That it's the functions, they also deal with the functions that a judge performs.
Sorry, Justice Turon, I must be clear. It is the Judges Remuneration and Conditions of Employment Act, and it provides for, the short title, the remuneration and conditions of employment of judges of the Constitutional Court, the Supreme Court of Appeal, and the High Courts, and for matters connected therewith. And so
it's matters connected with their employment. It's conditions of service. It's the benefits which they receive. How can that be extended to deal with their powers when they're discharging their functions?
Justice Turon, we don't endorse any attempt to cut and paste one definition from the Act to the other, but what we do say is when one is called upon to interpret what a judge means in Section 47(1), what the High Court did and what the judgments before it have done was to say, well, what is a judge? What does a judge do? What services does a judge perform to society? And when they interpreted that question, they had regard to, they got interpretive assistance or guidance from the Services Act, but the Remuneration Act, but we certainly don't suggest that there is an absolute ability to cut and paste from one to the other.
When I look at Section 47(1), it says, notwithstanding anything to the contrary in law, no summons or subpoena against the Chief Justice or Judge of Appeal or any other judge. Seems to imply on a simple textual reading, proceedings being brought against a judge. What we might be dealing with here is proceedings being brought against a judge arising from proceedings being held before a judge. So, but for that proceedings that was before the judge, there would not be an action. There would not be proceedings. Is that a distinction of note?
Justice Turon, I'm not sure, because I think that one of the reasons that Section 47(1) is in existence is to protect judges from claims arising out of their judgments to say, because of your judgment, I suffered X amount of damage, those kinds of frivolous and vexatious claims. So the mere fact that the proceedings against the judge arise out of proceedings...
Yes, I'm sorry to interrupt you again. That would not be against the judge NO. That would be against the judge personally for damages. If the claim is because of the behavior of a judge in proceedings, there's a claim for damages or compensation against them personally.
That could be so, Justice Turon. In this case, though, we say that, and I showed in my address, or attempted to do so, that this is clearly a case that traverses any NO boundary in the manner of the claims against Justice Khampepe and what has been pleaded against her regarding misconduct, etc.
My last question, you'll be pleased to know, Ms. Pufferton-Jones. This is something that my colleague Justice Matopo raised with Mr. Manechi, and what happens if this court has to find in favor of the applicants? Is that question before us? Is that question before this court as to what happens to the work the Commission has already done, the work the Commission will do in its remaining term, if this court was to find that the appointment was improper? Or what is your submission on that?
Justice Turon, we say that certainly what this court must take into account is that the Commission has a vital truth-seeking function in our democracy. There are victims that have waited decades for answers which this Commission has promised to provide. That is a relevant factor when this court looks at the kind of remedy or relief that might be granted. That is certainly something that should be taken into account.
See, that's my difficulty. I'm not sure the question of remedy and relief beyond a finding that the applicants are asking us to make is before us, and that's what I'm asking you, Ms. Pufferton-Jones. Is that question before us?
To the extent that this court is asked to declare that certain conduct or is unconstitutional under Section 172(1)(a), or frankly even without that declaration, then certainly this court must consider under, or may consider under Section 172(1)(b), the broadest just and equitable relief in the circumstances.
Where is that dealt with in the papers by the parties?
It has not been
Then
explicitly
how can the
dealt with.
court make a decision on that?
Justice Turon, I accept that the implications of what would happen to the Commission is not on the papers.
Yes, thank you. Thank you, Ms. Pufferton-Jones. Thank you, Deputy Chief Justice.
Ms. Pufferton-Jones, as we stand here today, would it be accurate to say that Justice Khampepe is a just judge of the Constitutional Court?
I beg your pardon, Justice Rogers.
Would it be a correct and accurate statement to say, as we stand here today, Justice Khampepe is a judge of the Constitutional Court?
No, Justice Rogers.
Now, it seems to me there's an aspect of the text of Section 47(1) that hasn't received attention, as far as I can see in the authorities and in the argument, and that is that the prohibition applies to the institution against any judge of a superior court. Now, if one looks through that phrase of a superior court or of a division, you will see that phrase used throughout the Superior Courts Act, and it is always used with reference to judges in active service. So, because it's partly relevant to Section 47(1), head of court is defined in Section 1 for courts of similar status to a high court, the most senior judge of such court. Now, that can't mean the most senior retired judge. It must mean the most senior active judge. That would be the head of that court. If we go to Section 4(1), this court consists of the Chief Justice, the Deputy Chief Justice, and 9 other judges of the Constitutional Court. That doesn't refer to Justice Khampepe or Justice Jafta. It refers to the in-service judges. If we go to section 6(4)(c), which relates to divisions with more than one local seat, the judge president of that division may assign all the judges of that division as he deems fit, or she. Section 7(2), circuit courts must be presided over by a judge of that division. Section 9(4)(b), one of the functions of a head of a superior court is to issue directions to the judges of that court. Now that must mean the active judges. He can't issue directions to the retired judges. And so I haven't gone, you or your co-counsel can do the search of a judge or judge of in the Act, and you'll see it's used throughout with reference to in-service judges. So when that same expression is found, it may not be instituted against any judge of a superior court. Why should it not have the same meaning? Meaning a judge who is currently serving in that court. As you said, Justice Khampepe is not, as we stand here today, and has not for some years been a judge of the Constitutional Court.
Justice Rogers, I can do no better than to offer to you the findings of Mlambo JP, as he then was, in Motata, who explained that this was new wording that was added, a judge of a superior court, in order to include constitutional judges, judges of this court who had not previously been included. And it was a consolidation exercise, not an attempt to strip judges of their protections.
I confess I would have to go back to that case. Was the significance of this as undertaken with reference to this formula which appears throughout the Act as being with reference to those currently in service at a particular court?
No, Justice Rogers, it certainly wasn't done with that level of granularity that you've given to me now. But my answer to you is that the inclusion of the words of a superior court simply make it clear that it applies not to magistrates, and it does apply to all judges of all superior courts, including the Constitutional Court.
Yes, how the provision would have been interpreted in the context of the old Supreme Court Act, I don't venture an opinion, but we must now take it as we find it. Now, if there is a concern that Section 47(1) impacts on access to court and opposes, I take your submission that it's not an absolute bar, but it's a gateway which may or may not be opened to the litigant. If giving the section the width that the respondents are arguing for raises discomfort, then at least one entirely plausible reading is to say that it is the judge of a court, in other words, a judge currently serving in a court, where the prohibition applies. I accept that there might be certain illogicalities with that, because I know that an active judge could also be seconded to sit in a commission, and then that person would still be a judge of the court where he serves. But at least this interpretation, which seems to me to follow the scheme of the same phraseology throughout the Superior Courts Act, would say that it doesn't apply to retired judges, because none of them could be regarded as, we wouldn't say today that Fritz Brunt is a judge of the Supreme Court of Appeal. He was, and he's no doubt very grateful that the Remuneration Act allows him to be remunerated with reference to the salary of a Supreme Court of Appeal judge, but he isn't now a judge of a superior court. And we would at least then rule out all the retired judges from the protection. Oh, sorry, yes. And that might then tie in with such the purpose that then comes in subsection 2, which is making sure that the judge against whom a consent has been given isn't then called to appear in court in a way that will disrupt the work of the court.
It would give effect to that, Justice Rogers, but it would then undermine the protection that sitting judges have, knowing that they cannot be challenged down the line for the judgments that they've issued while they are active judges, because the retirement then operates as a guillotine.
Yes, but perhaps that is not the primary purpose of Section 47. I don't know if you've read the bit of academic literature which went into the history of Section 47 as it now appears. South Africa and one or two of our southern African neighbors who have borrowed it are the only countries in the world which have this gateway provision. So it hasn't been regarded as necessary throughout the world for this protection to exist in order to secure the independence of the judges. There are other civil law absolute or qualified privileges which protect judges from claims for damages in respect of the work they do. But for the rest, I would very much hope that a judge doesn't need this in order to do his or her job. So the primary purpose may be the more mundane one of making sure that in-service judges are not unnecessarily distracted by frivolous lawsuits which may interfere with their work.
Justice Rogers, I would simply respond to that by saying this is the tool that South Africa has chosen, and we don't have many others to protect judges.
I think we have the normal rules that would apply in the civil law in other countries, that you can't be sued for having given a negligent judgment, you can't be sued for defamation for things you say in a judgment. Those sorts of protections exist as a matter of common law. I'm just not sure that if there are other statutory protections which you say in other countries serve the purpose which this serves in this country, I would be interested to know. But if, as I suspect, it stands virtually on its own worldwide, it might not be regarded, it might not be in the Act as some fundamental bulwark against diminishing the independence and fearlessness of the judges. Just raise the language of a superior court, because it seemed to me potentially of some significance.
Thank you, Justice Rogers.
Steve?
Ms. Palvin-Jones, when you dealt with the issue of the improperly constituted decision maker relating to the recusal, I heard you say that it is proper for the recusal application to be heard by all 3 members, but to be decided by only one of them who is implicated in the application. And you made reference to the Sarfu judgment. Are you able to provide me the passages that support that proposition?
Certainly, Justice Nuku. I also know that it's an issue that my learned friend is going to deal with
Or you want
in some
to
detail.
leave it to, you
I
can
certainly
leave it
provide
to
you the references, but it's an argument that my learned friend, Mr. Budlander, will
All right,
expand on. So thank you very much, Justice.
Thanks.
Okay. Thank you, Advocate Purifin-Jones.
Thank you,
That
Deputy.
seems to be it from a question point of view. Advocate Budlander. I see that a number of curveballs have been thrown your way by your partner in arms. Please go ahead.
Deputy
when
Chief
you're ready.
Justice, members of the court, our individual clients are 25 families who have been trying for more than 20 years to obtain justice for themselves and for their loved ones who died at the hands of the apartheid state and its agents. To do this, they have had to revive and they've had to relive the pain they suffered from those events. They've done so because they need justice, they need accountability, and they need closure. The Rodriguez case in the Supreme Court of Appeal illustrates this. That case dealt with the death of Mr. Ahmed Timel, and he fell to his death from a window on the 10th floor of John Foster Square in an office used by the security police. Justice Kachalia said, quote, "The Timel family have been the victims of this delay. They have waged what can only be described as a heroic struggle with dogged determination to bring the alleged perpetrators of these crimes to trial. The public interest demands that their efforts are not in vain." Close quote. In January 2025, the Kalata Group applied to the Pretoria High Court for an order directing the President to establish a commission into the suppression of the investigation and prosecution of TRC cases. And the President then established this commission, and it has been hearing evidence from a number of people. It is now more than halfway through its task, because it has less than 6 months to go. If the present applications succeed, they will collapse the Khampepe Commission, and they will bring the whole process to a halt, and possibly render the whole process a nullity. Mr. Mbeki and Mr. Zuma will not have to file statements explaining their conduct as directed by the Commission, and they will not have to appear before the Commission and account for their conduct. That is in my submissions, I'm going to focus principally on the review issues, the review grounds. I'm going to say something briefly about Section 47, but for the most part, I will be dealing with the review grounds. And in that context, I'd like to go out of sequence immediately to the question of the HRIU, which enjoyed so much attention in the discussion with the members of the bench. Our learned friend for the Commission has drawn attention to some of the facts in this regard. I'll try to repeat those parts only very briefly. But the question is, what are the facts before the court? What facts does this court have before it in relation to the HRIU? Mr. Mbeki says in his answering affidavit, if I can give you the reference, it's paragraph 241.8, and that must be his founding affidavit, I think, and it's case lines 001-217. He says, and I quote, "The precise nature of Justice Khampepe's involvement in the HRIU requires further factual investigation. The uncertainty is material." Trenchant observations. In fact, in the High Court, the Commission denied that Justice Khampepe was part of the HRU, and Justice Khampepe confirmed that denial in a confirmatory affidavit. You've been given the references by a learned friend. The fact is that there is no evidence before the court by anybody with knowledge of the facts. I'm not talking about somebody who speculates about it, but there's no evidence by anyone with knowledge of the facts that Justice Khampepe was part of the HRIU, or to the extent, if she was, what the function was of that unit. The facts are lacking. There's been a debate on the assumption that she was a member, and B, the function of the HRIU was to look at stopped prosecutions and to consider why they were stopped. But there's no evidence whatsoever of that, and in fact the evidence is to the contrary, because she says she didn't do that. She wasn't there. And I'd like to show the court some further passages which underline this. In her decision on the application for recusal, Justice Khampepe said the following. I can just go there. It's at page 001-962, and she said the following. At paragraph 42, she said, "It is common cause that I sat as a member of the Amnesty Committee of the TRC over the period 1996 to 2001. It's also common cause that I was appointed as a Deputy National Director of Public Prosecutions over the period September 1998 to December 1999. She then says, on page 45, paragraph 45, former President Zuma ignores the fact that the issue of efforts or attempts having been made to stop the investigation or prosecution of TRC cases were not matters that were pertinent before the TRC's Amnesty Committee, or indeed at the National Prosecuting Authority during my tenure there." That's what she says. She says this issue was never before them. And then further, if one then turns to what Mr. Saldanha says, Judge Saldanha, he says the following, and you'll find his statement at case lines 001-992. At paragraph 3, he says the following. He says, "I served as the chairperson of the Human Rights Investigative Unit. The unit was charged with the consideration of dockets referred to the NDPP by the Amnesty Committee of the TRC for prosecution. The dockets related to persons who had not applied for amnesty and who were unsuccessful, and also those persons who had not applied for amnesty. The unit reported directly to the NDPP, not to Justice Khampepe, but to the NDPP. And then he goes on, in paragraph 8 on the next page, he says, I recall, though, that during the course of, he's saying that he hasn't got any documents. He then says, I recall, though, that during the course of 1999, an interim report was prepared by the committee, which was submitted to the National Director of Public Prosecutions with regard to the matters that we were at that stage considering. And what were they considering? They were considering the dockets. And so the suggestion that the HRIU was investigating the matters now being investigated by the Commission was simply not only not supported by any evidence, it's contradicted by the direct evidence. And so we submit that no evidence at all, no reliance at all can be placed on the allegation, unsupported by evidence, that Justice Khampepe was a member of the HRIU. It's denied under oath by those who know, or that in that capacity the HRIU was investigating interference with the NPA. That's also denied on the record. And so this whole construct of Justice Khampepe sitting in one place, deciding one thing, and then sitting in another place and deciding the same thing and giving rise and implementing the decisions she'd made previously is simply false. It's not supported by the evidence, and in fact it's contradicted by the evidence. That then brings me to why we say that this application should be dismissed. I'm not going to repeat what our learned friend for the Commission has said. We say that make the following submissions. First, that the applications were not urgent when the whole matter was started. And we say that if there was any urgency, it was a classic case of self-created urgency. Because the Commission was established on the 29th of May 2025, the President announced who would be the chairperson, and he announced what the Commission would investigate. Mr. Zuma and Mr. Mbeki don't say that they weren't aware of any of this. They don't say they didn't realize that this was going to affect them. In fact, they don't say that at all. They simply did nothing. They were content for the Commission to proceed with its work. Mr. Mbeki clearly knew what the Commission was going to do, because he brought an application to intervene in the litigation about the establishment of the Commission. And so he knew all about it. He made an affidavit dealing with that. Notwithstanding that delay, there was then a further delay. In October, beginning of October 2025, Mr. Zuma learnt that a Rule 3.3 notice had been issued against him. He did nothing of it. He didn't take any step to challenge it. For 2 months, he didn't raise any objection at all to it. He just continued. And he's never given any explanation of it. By then, Mr. Zuma must have known, certainly from the notice, what they were investigating and he knew who was investigating it. He did nothing to challenge that. Mr. Mbeki is in a worse position. He says that he received the notice on the 25th of September. He raised no objection to Justice Khampepe for nearly 3 months. On 19 December 2025, he launched his application for Justice Khampepe's refusal. And he, as I say, knew exactly what it was all about, better than anyone else. And so we say that the appellants have delayed considerably, that everything is put on this court now, that this court must decide the matter urgently because of the time. But what's it caused by? It's caused by the fact that there was no objection raised at the time that the commission was established. Excuse me. And there was no objection raised at the time when they were issued with the Rule 3.3 notices. Nothing. So now it's all very urgent, and you're told, oh, you must deal with this now, because otherwise we'll be denied substantial relief. We say this. We say the applicants will suffer no irreparable harm if the Commission is now allowed to complete its work. Its findings will bind no one, and if they disagree with the findings, they can vindicate their name in the media. These are two people who have ample access to the media. They've got more access than anyone else. And if the Commission errs, they can bring review proceedings. And so we say that there is no irreparable harm that will be suffered that requires an urgent relief. Then secondly, we say there are no exceptional circumstances which justify a direct appeal or direct access. We submit that it is overwhelmingly in the public interest and the interests of justice that the Commission be allowed to complete its work. And we say there are no exceptional circumstances that justify this court now rushing in and deciding this issue. A learned friend for the first applicant referred to the Ramakatsa case. Ramakatsa case was entirely different. In the Ramakatsa case, what would have happened if this court hadn't intervened is that elections which had taken place and which were allegedly irregular would stand, and the court said, for 4 years, the province will be under the administration of people who were irregularly elected. And the court said, we can't stand for that. The court said that the allegations go to the core of the propriety of the election in the Free State province. And so the court intervened. This is not a case of that kind. Further, we submit that there is no prospect of success in the appeals. I'm not going to deal with the Section 47 issue, which seems to have been done to the death to our, I think, the mounting confusion on the part of all of us. I will say this. Firstly, that the debate today illustrates that there is good reason for this court to await a decision of the SCA before finally committing itself. There would have to be a very good reason for this court to rush in and make this decision without the benefit of the SCA, given the doubt about it. Secondly, we submit that whatever Section 47 means, it must surely apply, given what its purpose is. Given that its purpose is to protect the judges in the performance of their duties, and given that under our law, a judge is a judge for life, as Justice Sutherland held in the Sariti case, we say it must surely apply to a judge who is performing judicial service, which includes sitting on a commission, whether or not retired. Secondly, it must apply to an application which attacks the judge's performance of her functions as a justice of this court, which is what is before you today. Thirdly, we say it must surely apply to a case in which there is a personal attack on a judge, who is the only person who can answer it. For example, the allegations of actual bias and as well as institutional bias. And we submit that it's not necessary and not desirable for the purposes of this case to decide whether the Section 47 only applies to proceedings against a judge for the performance of their duties, performance of their service as a judge. It's enough to say that it certainly applies to a case such as this and leave over, including to the SCA, whether it applies to retired judges in other circumstances, whether it applies to judges who are not performing judicial work at all, and so on. So we therefore make the submission that the Section 47 appeal on these facts doesn't succeed. Whatever the meaning of Section 47 mean, it shouldn't succeed on these facts. Finally, in this regard, I need to point out that what Justice Malambo said in the Matata case in his judgment, he explicitly included in the term judge, judges who have been appointed to perform the functions set out in the Remuneration Act. Then a further reason for dismissing the appeals we submit is that there's no prospect of success in the reviews. We deal with this in our heads of argument from paragraph 79 to 113. We say first, the test for bias in a case such as this is not the same as the test that applies to a court. Someone sitting in a commission of inquiry which has no power to decide rights and obligations and has no power to bind anybody is not subject to the same restraints as someone sitting in a court who's making determinations of rights and obligations. And that's what the Canadian Supreme Court has said. The Canadian Supreme Court in the Baker case, which we quote in our heads in paragraph 86, said, "It has been held that the standards for reasonable apprehension of bias may vary, like other aspects of procedural fairness, depending on the context and the type of function performed by the administrative decision maker concerned." Here, the type of function is not a function of judicial decision making. It is a function of giving advice, looking for the facts and giving advice. One can think of many examples of this. Think, for example, of members of a parliamentary committee who are called upon to decide matters. They come to that committee with predispositions, with political opinions, with political allegiances to their party. They can't be disqualified on the grounds that they're politicians who have political opinions. That's who they are. And the test for bias against politicians on a parliamentary committee would be different from the test again, in respect of a judge sitting in a trial. Similarly, in a commission. We make the observation or submission that in fact there can be given the nature of what a commission does, given that it's there to provide advice, not just to find facts and figures, that there can be a positive benefit if one of the commissioners has some background knowledge of the matter, some institutional knowledge. It's not a disqualifying factor. It can be a positive advantage, as long, of course, as the judge or the commissioner keeps an open mind. That's the test. So we then submit that, I hope it's now self-evident, that Justice Khampepe's role in the Amnesty Committee that has no bearing on what the Commission has to decide. We've hardly heard about the Amnesty Committee today, and for good reason, because the Amnesty Committee had to decide whether particular people should be given amnesty. The Commission has to consider whether there was pressure on the SAPS and the NPA to stop investigating or prosecuting cases. The two are entirely different. A decision that X or Y should or shouldn't be given amnesty has nothing to do with whether members of the SAPS or the NPA were pressured to stop or not to investigate or prosecute a TRC matter. So those are the core submissions on the, oh yes. So then can I move to the SAFU case, which is whether the Commission erred or whether Justice Khampepe erred in deciding the matter on her own. The SAFU case has been repeatedly referred to, but has not been quoted. I want to read, if I may, to the court what the Constitutional Court said in SAFU. Paragraph 31. Judges have jurisdiction to determine applications for their own recusal. That's the starting point. Then paragraph 32. If one judge, in the opinion of the other members of the court, incorrectly refuses to recuse herself or himself, that decision could fatally contaminate the ultimate decision of the court, and the other members may well have a duty to refuse to sit with that judge. So what is happening, the court says, is that the person impugned makes a decision whether or not to recuse himself or herself. And the other members then say, well, in the light of that, can I continue to sit with you? That's how it works. That's what the Constitutional Court said. And they referred to the Pinochet case in that regard, and they say it follows that if a judge incorrectly refuses to recuse herself or himself, the remaining members of the panel should not sit with that judge, as the proceeding would be irregular. So they don't vote and say, we vote by 5 votes to 1, or by 10 votes to 1, or by 2 votes to 1, that you must recuse yourself. That's not how it works. How it works, is that the person who's impugned decides whether to recuse themselves, and the other members may then say, well, Well, we don't agree with that. We can't sit with you under those circumstances. That's what the judgment of the Constitutional Court says. In the order made by the court, paragraph 2 says, the applicant has failed to establish that, objectively regarded, there are grounds for any of the 4 judges to recuse themselves. That's a finding by the court. But then the critical part, paragraph 3, each of the 4 judges concerned agrees with this conclusion insofar as it applies to himself and declines to recuse himself. So it was the individual judges who decided whether they were going to recuse themselves. It wasn't the court which decided whether they had to recuse themselves. They made the decision and they decided not to recuse themselves. And so the authorities with regard, or the key authorities with the right, is absolutely clear that when a challenge is made to a member of a panel, that member decides whether to recuse themselves, and the other members of the panel then choose their own course of action in the light of the decision made by that member. So there's nothing wrong with Justice Khampepe. Whether by accident or with knowledge of this, she made the right decision. She would have made the wrong decision if she said the decision is going to be made by the 3, because what the law requires is that she must make her own decision, and that's what she did. Then I need to say something very briefly about the complaint about counsel for the Galata group being allowed to lead their witnesses, that this is one of the grounds on which Justice Khampepe should have recused herself. We say that with due respect, it's frankly absurd, because the facts are the following. Firstly, when the applicants objected to this arrangement, the chairperson had a hearing on whether this should be done. The undisputed evidence of Mr. Galata in his answering affidavit is that this is what is done generally by commissions of inquiry. If I can give a bit of evidence, I know of that. Thirdly, the undisputed evidence of Mr. Galata in his answering affidavit is that the same arrangement has been made with all of the parties who are introducing witnesses to the Commission. So there can be no suggestion that this decision shows any bias in favor of the Galata group or against the applicants. This is what has been done with all of the parties which have said to the Commission, we have a witness and we'd like to introduce this witness as evidence to you. So the raising of this point is, with due respect, a mark of the applicant's desperation to avoid having to provide explanations of their conduct and having to give evidence. It is a complaint which has been raised again and again and again, and it's simply without any substance. In conclusion on this point, I make the following submissions. Firstly, in Rodriguez, the full court of the Pretoria High Court made the findings through Justice Colopin, or Judge Colopin as he then was. They're in our heads at page 006, paragraphs 2 to 4, they are trenchant. There was deliberate obstruction of the National Prosecuting Authority by the police. And the National Prosecuting Authority was interference by the executive at a senior level with the National Prosecuting Authority, and that is why the National Prosecuting Authority didn't prosecute these cases. That's a finding made in the Rodriguez case by the full court in the Pretoria High Court. That's what actually happened, and that's what has given rise to this situation. What the Commission now is to find out is who gave those instructions and why. We submit that it will be a travesty if the Khampepe Commission, now more than halfway through its work, with less than 6 months to go, is now collapsed by the intervention of former President Mbeki and former President Zuma, two of the people who have most need to explain what happened after 2003 and what their role was in it. If it will be a travesty of justice, if the Khampepe Commission is now collapsed, all of the work it's done is rendered a nullity, and who knows what, if ever, will happen to deal with this blot on our history and on our present. We make the submission that it's a trite saying that justice delayed is justice denied. And in this matter, justice has been denied for more than 20 years. As a result of the persistence of our clients, we are finally on the threshold of accountability for what happened. Key players have already given evidence, and others are to follow, including the two applicants in this case. we make the submission that there is no substance in the complaints of bias. The institutional bias was 30 years ago, and it was, for the reasons I've explained, there's no problem in principle with a member of a commission coming to the commission with some knowledge of the context. We've made a submission, that's 30 years ago, the institutional bias. The bias based on the alleged participation in the HRIU is meaningless because there's no evidence to support that, and neither does the evidence, and the evidence shows, A, that Justice Khampepe didn't participate, and B, that that unit anyway didn't investigate anything related to what the Commission is investigating. It was looking at dockets to get them ready for prosecution, a rather different task. And so, and thirdly, the bias relating to the calling of witnesses is, with due respect, utterly without foundation. And fourthly, the complaint that the Commission, or that Justice Khampepe made the decision herself when she shouldn't have, is simply wrong in law. So for all of these reasons, whatever you do about the Section 47 issue, and we submit that the court should do as little as is necessary, as is essential with the Section 47 issue, we submit that there is no basis whatsoever for the bias complaint. There's no evidence to show that Justice Khampepe is institutionally biased, personally biased, or biased in any other manner. And so we respectfully submit that it cannot conceivably, in the interests of justice, for justice to be further delayed and denied. We submit that the Commission should be allowed to continue with its work. If the Commission ultimately gets it wrong, Mr. Zuma and Mr. Mbeki have their remedies. They have their remedies in the court of public opinion. They have their remedies in their ability to go to court and ask a court to say that what the Commission found wasn't justified. There's no need for the whole process to be collapsed now simply because they are concerned about having to give evidence. And particularly we submit in circumstances where they delayed at the lowest 75 and 90 days, actually for 6 months before they took any steps to challenge the appointment of Justice Khampepe to the Commission. They can't do that and then come and try to press gang this court into doing something urgent because they're in trouble. They're not in trouble, they're able to look after themselves, the law will enable them to look after themselves, and the one thing they can do is look after themselves. Those are our opening submissions, Chief Justice.
Thank you, Advocate Butlander. Just assist me, I need to understand your submission about how to deal with the recusal application and how it was handled. Am I correct that that recusal application was brought to the Commission?
Yes.
Which is Justice Khampepe and 2 others. That's the Commission. And is it correct that she's the one who decided it, or is it the Commission that decided it?
I think the evidence shows that she decided.
She decided it. You made some submission about why that was so.
It shows that the evidence that she decided is that she herself signed the decision. There was nothing saying that the other members concurred. She said, I've decided this, I that, and I the other. And in the pleadings, in this case, she doesn't suggest that the decision was the decision of the 3 of them.
Could it be the reason that the whole purpose and activity around that application was against her?
It was indeed.
Right.
It was a classic recusal application saying, here's a 3-member panel, one of these members should be recused, should recuse herself.
So the ruling then, is it the Commission's ruling or is it her ruling?
It's with respect to her ruling. It's her decision. It's not even really a ruling. It's not a ruling of the Commission at all. It's a decision of Justice Khampepe not to recuse herself. Just as it was a decision of the 4 justices of the Constitutional Court not to recuse themselves in the Safu case.
Thank you, Advocate Butlander.
Glenda, just one aspect. I heard you saying that this arrangement with witnesses that have already testified and those still to come is an arrangement with all the parties who intend calling witnesses.
That's the evidence of Mr. Tsalata, yes. It's not disputed by anyone.
Two questions. Does this also relate to evidence or witnesses that may be led by the present applicants or not?
Well, one would have to do it to see what happens, but it would be very surprising and would require special justification if the Commission, having said to everybody else, you can lead your own witnesses, we're now to say to the two former presidents, but you may not do so. One must assume that the same rule will be applied to all. So there are really two sorts of witnesses in a commission such as this. There are witnesses who are contacted, organized, consulted with, and prepared by the Commission's evidence leaders. And the Commission's evidence leaders typically lead them. But there are always, or very often, outside parties who've got witnesses they want to bring. Very often they consult, they prepare statements, they give them to the Commission, to the evidence leaders, and they say, we would like to lead these witnesses ourselves. And the evidence of Mr. Tsalata is that in all such cases so far, this has been accepted.
Thank you.
Mr. Butland, I'd just like to clarify one aspect of your address, is that you contend that it would be a travesty of justice if all the work that has happened would come to naught and the clock would have to be turned back. But I understand you premise that on the facts of this particular case. You would accept that if there was a proper case to interpret 47 in the manner in which the applicants want us to, and if that gets us to the merits of the review and we find there's merit in the review, then that is a consequence that must follow.
Well,
but I understood you saying that we shouldn't dismiss it simply because that's the consequences. We should dismiss it because that would be the travesty would be that you would dismiss it in the face
of these facts,
of the absence of a cogent case for, well, either interpreting 47(1) in the way in which the applicants want, and then finding in their favor in terms of the review grounds they want.
yes, of course, if this court decides that the Section 47 is to be interpreted as the applicants would have it, then the review application should not have been dismissed on that ground. That then leaves standing the question of bias, the other review ground, bias and sitting alone. And that would have to then either be sent back to a court, maybe not that court because one of the members is already committed, but or it would have to be decided by this court on the basis that Justice Rogers has decided. But I need to emphasize that if the Section 47 point is decided in favor of the applicants, that doesn't bring an end to the work of the Commission. The question for the work of the Commission is whether grounds have been shown that Justice Khampepe ought to have recused herself. They say, agter ons kom ook in die kraal.
Mr. Budlander, the test for bias would be reasonable, or is it apprehension of bias by a reasonable person? How would you define it?
Well, the test for judicial officers is reasonable apprehension of bias that would be held by a reasonable, what was held and was held by a reasonable, or would be held by a reasonable person.
Yes.
So double reasonableness test, yes.
Yes. Now, we know this is the opinion of the President, but what weight should we give to, that's the current President I'm referring to, President Ramaphosa, what weight should we give to his affidavit in the High Court where he says, had he been aware of Justice Khampepe's previous involvement with the TRC and the NPA, he would not have appointed her.
We submit
Is he a reasonable person who's apprehending bias?
Well, Justice Theron, we don't know what the President knows. We don't know what he's been told. he's probably been told a story about the HRIU, which is without any factual foundation. He's possibly been told a story about the Amnesty Committee, which is without factual foundation. And so the fact that he holds this opinion tells us really with respect nothing unless one knows on what basis he reached that conclusion. And so it is interesting, it is a curious quirk.
Let's interrupt you. Let's look at what he says. He says if he had known about Justice Khampepe's involvement with the TRC
Yes,
and with the NPA,
yes,
if
Well,
he
there
had
you
known
go.
about that involvement,
yes.
he would not have appointed
Well, it
her.
sounds like he was misinformed about
Yeah.
her involvement. It sounds like he was misinformed about her involvement with the Amnesty Committee. He wasn't informed that it had nothing to do with the obstruction. And it sounds like he was misinformed about the HRIU, that he was informed that she was a member of that unit when it appears that she was not on the facts before this court.
Let's assume that he wasn't informed of all the details, but he was informed, and this is what he says, of her involvement with the TRC and the NPA at that level. If he says that he had not been, if he had been aware of that involvement, let's assume he means at any level, he would not have appointed her.
Well, if his view is, his position is that if he'd been aware that Justice Khampepe ever had any involvement with the TRC and the Amnesty Committee and with the NPA, he wouldn't have appointed her. One will say, well, that's very interesting. We respect your decision. You would have been entitled to make that decision. But that doesn't provide a ground for accusal. That doesn't justify a conclusion that there was bias. He may, for example, have said to himself, well, we don't know what he said. And I don't want to speculate as to what he said. But what we do know is that it seems he thinks that she was involved with the HRIU, which she wasn't. His opinion, therefore, was based on a factual misunderstanding, and at least one factual misunderstanding. And I'm sure he made the statement in good faith, with the best of intentions, but with due respect, it doesn't assist this court in deciding whether there is a ground for disqualification on the grounds of bias.
The fact that the date period for the terms of reference of the Commission is after Justice Khampepe's involvement with the TRC and with the NPA. Is it possible that information obtained or connections made prior to 2003 could impact on the investigations conducted from 2003 onwards?
I have no instructions on this, but as a matter of logic, it is conceivable that events in 2000, 1999, 1998, impacted on the decisions, on the actions of people who, after 2003, who obstructed prosecutions. It's completely conceivable. Whether the facts demonstrate that, of course, we'll have to see. But I accept that there can't be an iron curtain which slams down on the 1st of January 2003 and says everything before that you can't consider. It may, depending on what it is, be relevant.
Doesn't that impose a potential harm on the part of Justice Khampepe and her prior involvement?
Well, if she had been involved in decisions, or party to decisions prior to 2003, that prosecution should be stopped. Let's say, for example, there was evidence produced of a letter written by Justice Khampepe in 1999 to somebody else in the NPA saying, look, it's time to stop all these prosecutions. They are going to cause political difficulty, they're going to cost us, and lots of people on both sides are going to be prosecuted, and I think we should have no more TRC prosecutions. If there were evidence of that, that would be very material to what happened after 2003, when the prosecutions were in fact stopped. But of course there's no evidence of that kind whatsoever.
Now, I know I might be asking you to speculate in the next question, Mr. Butlander. If for some reason Mr. Bulelani Ngcuka was not available to testify at the Commission, and if Justice Khampepe was not the chairperson? What's the likelihood of his deputy being called as a witness before the commission?
Well, it is highly speculative, Justice Turan, but I think the short answer is from what she said in her ruling, where she said, if I can just lay my hands on it. She says in paragraph 45, President Zuma ignores the fact that the issue of efforts or attempts having been made to stop the investigation or prosecution of TRC cases were not matters that were pertinent before the TRC's Amnesty Committee or indeed at the National Prosecuting Authority during my tenure there. So if somebody else were chairing the commission and she were called as a witness, she would presumably say, I don't know about this because I didn't see any of this when I was there. She was only there for a year, remember. But she says that certainly had nothing to do with the Amnesty Committee or at the NPA. If called as a witness, she would have to say on the basis of what she said, I know nothing about that. I can't help you, sorry, find somebody else.
Do the respondents say that the applicants have gone far enough to establish Justice Khampepe's links or ties or involvement with the HRI unit?
Justice Turan, may I recount a story? I was once in court where Judge Dennis Davis was sitting, and one of counsel said, my lord, I can't take the point any further. And Dennis Davis said, no, you haven't taken it anywhere yet. And that's the situation here. They haven't taken it anywhere yet. It's not that they haven't taken it far enough. They've got nowhere.
That appears to be it, Mr. Butlander. But just before you sit, I think in your main submissions, you said there's no evidence that suggests that Justice Khampepe was involved in that HERU unit. And none of the two applicants tells us anything substantive in that regard. That's what you said.
Yes. Well, the way it happened, the way it arose, Justice Malambo, is that there was an objection raised by Mr. Mbeki and Mr. Zuma to Justice Khampepe's participation. And the attorneys for the Talata group then wrote complaining about this and saying, you can't just raise these things after the event out of the blue. We're just going to tell you that if you're going to object to anybody else, this is the time to do it. And they said, and one of the things they said, I can just read their letter so that I don't misquote it. But they said, it seems that Justice Khampepe had some involvement with the HRIU or something of that sort. I just need to find the letter. You got it? And that triggered, here we go. It's a letter of the 11th of November 2025. And second page, it's at page 001897. And she says, they say, we're concerned that down the road some parties may be preparing further applications that may also disrupt proceedings. In order to avoid more time being wasted, we wish to bring to the notice of the Commission and the parties the earlier roles played by members or staff of the Commission in TRC-related work or matters that might be connected to the mandate. They say we don't think any of them should be disqualified. They then go through them and then they say 12.2, in 1995, Chairperson Khampepe was appointed by former President Mandela as the TRC Commissioner, and in the following year she was appointed as a member of the TRC's Amnesty Committee. But 12.3, between September 1998 and December 1999, Chairperson Khampepe was a Deputy National Director of Public Prosecutions. During this period, she apparently played a role on the Human Rights Investigation Unit, established by then DPP Bulelani Nuka, to advise him on how to handle the cases referred by the NPA to the TRC. It should say by the TRC to the NPA. And that's what sparked off this frenzy of excitement. But that's the closest there is to any evidence that the attorney said She apparently played a role. There's no evidence that she ever played any role, and she denies it.
See. The apprehension of bias by the applicants, it's not against the commission, it's against her.
Yes.
Okay, thank you, Mr. Butlander.
Thank you, Deputy Chief Justice.
Could we adjourn convenience break for about 10 minutes before we come back for the rest of the hearing? Thanks.
They were so good.
from now.
Yes, well, you can start around.
Yeah, I can end something.
How long do they give you?
I think they give 10 minutes.
So tell that to your comrade.
Do you remember that day when you were speed reading to them in this parliamentary stuff?
Yes, yes, yes.
You have to speed read. If they stop you, that's it.
Yes, exactly.
What do you mean again? What do you mean? Everyone knows my case. My case is the most simple.
So you're replying?
Yeah, no, she's going, I think,
Oh, you're still going, yes.
15 minutes.
No, 10. Look, it's in front of there.
Yeah, well, that one you brought it to yourself.
Yeah, but
Good evening, everyone. Please switch your phones off. Court is about to sit.
Deputy Chief Justice, may I just draw the court's attention to an error in our heads of argument? I wouldn't like it to stand. There's an error in the last sentence of paragraph 93, and the correct position is stated at paragraph 95.4. So the last sentence of paragraph 93 is not correct, and the correct position is stated in paragraph 95.4. Thank you, Chief Justice.
Paragraph 95 is the correct one.
95.4 is the correct one.
Thank you.
Thank you, Deputy Chief Justice.
We will not hear sixth respondent because your issue has not been raised in oral argument. Six. Is it seven?
It's the seventh
Oh yeah,
respondent.
seven. Sorry. You forgive me. Yeah, we will deal with that issue on the papers because there are affidavits filed, isn't it?
As the court pleases.
Your issue.
Okay, if I may just inquire from the court, which of the two issues, because there are two issues that the seventh respondent brings before the court. One is the condonation
The
application.
condonation.
And then the second, of course, is
The
the
condonation.
explanatory affidavit where we seek particular answers when that issue has, I think, has been canvassed
Yeah.
quite a bit.
The condonation. Yeah. This is the condonation.
It's the condonation.
You have nothing else to say.
Well, Deputy Chief Justice, our condemnation was also premised on our explanatory affidavit, on why that explanatory affidavit should be accepted by the court
Yes.
itself. So, in fact, what we're asking for was two relief. The first being to condone the late filing of that explanatory affidavit, and then the second is the acceptance of that explanatory affidavit and the contents thereof.
Okay. So you want us to look at both, but on the papers.
I am happy for the court to do that, but if I may just be allowed then to just state what then the conclusion that the NPA would have made on either of the two without taking much time, I could do that in a minute or two.
Okay. No, thank you. Thank you very much. And I think, counsel, for the president, you are just here to, you've got a watching brief, basically. Thank you. Advocate Mpofu.
Then, Deputy Chief Justice, sorry, if I just asked for that 2 minutes to just give the conclusion of both of what we've asked.
To do what?
To give a conclusion of what the NPA really asked of this court and why it is
But it's in the
important.
papers. Is it not in your papers?
There's also the issues that are raised by the Galata group in their papers in the answer.
Okay.
That are not in any of the papers because
Go ahead.
there isn't a right to reply in this court.
Yes.
And it is for that very reason that we would just want to deal with that. So just to deal with two issues on the objection itself, and I accept we have filed heads and we stand by those heads. The first objection that they make is that our affidavit does not assist the court at all because the court is seized with only the section 47. Well, the NPA says after the debates that you've had and equally after all the papers that were filed, I don't think they would still hold to that objection at all. Then the second and most important of the objections is that the Galata group indicates that there has been a denial of what the NPA has been asking in the explanatory affidavit, which simply put is this: did Justice Khampepe at any point in time in deciding the NPA application for the recusal of Advocate Semenya, coach Advocate Semenya, because that has a direct bearing on what the NPA then can do, because Deputy Chief Justice, as you know, the NPA has decided to abide, but unlike the President, they have said, well, our decision to abide is based on the fact that the people who have direct knowledge of the allegations are deciding to keep silent. And they continue to keep silent even before this court. And it is for those very reasons then the NPA says, when you then consider our explanatory affidavit and when you consider the case as a whole, think of also the parties whose rights actually will be impacted by that silence. In actual fact, one of the things that we equally say, that silence has a direct bearing, in fact, on the report that will eventually be done by the very person that is deciding to keep silent. if there's ever been any time, just to conclude, if there's ever been any time where the Calata Group and the NPA actually should agree on something, it is on this duty of candor, because the commission is there to be a truth-finding function, but in that very breath has refused to, in fact, deal with direct questions. So the NPA hasn't done what other parties have done because it doesn't have the facts. It has asked, are these allegations true? And it does that, question by question. In the High Court, I think Justice Taran asked my learned friend for the Calata Group, what should this court make of the affidavit by the president? Then if that question is true for the NPA, it would be that this court needs to accept that affidavit, and also accept that there is absolutely no answer to that affidavit. In instances where both Justice Khampepe and Advocate Semenya have filed in relation to everything else that was before the High Court except that particular affidavit. So that would be the conclusion to our submissions.
Thank you, Ms. Ntloko.
Thank you, Deputy Chief Justice.
Deputy Chief Justice, I'm sorry to interrupt. This is simply a misrepresentation of the facts, and I need an opportunity to answer.
Advocate Badlander, let's just deal with this. What, do you want to respond?
I want to respond, or perhaps I can draw the court's attention to the paragraphs in our affidavit which address this, where there is the specific denial of coaching is quoted. It's a paragraph.
You're dealing with the silence submission.
The silence submission, yes. It's at page 004-31, which quotes Mr. Macha saying the allegations remain unresolved and unanswered. And we point out paragraph 13.1 in response to the specific allegations of coaching.
Just hold on, Advocate Badlander.
I'm sorry.
Do you mind just taking a seat? Ms. Ntloko, please come back. Looks like you asked for questions. You're going to get them.
Deputy Chief Justice, I'm not sure I did.
Yeah.
I was quite happy to be silent until the Calata Group brought us
Justice
to say
Matopo
something.
has...
I'm not sure what you did and what was the purpose of what you were doing. And because it has left me with many questions, that's why Advocate Badlander stood up to try and clarify what needed to be clarified. What is it that the NPA wants to do?
Thank you, Justice Matopo.
Because unless you express it, I would not know. Perhaps you may have to deal with
what
the
he's
anticipated objection.
Thank you. Well, what the NPA seeks to do is to ask this court to have regard to its rights as well, considering the silence in relation to the allegations that have been made against the chairperson and the chief and business leader. As you will recall, Justice Matopo, the allegations relate to the NPA's application for the recusal of the chief evidence leader. However, the NPA says to this court, I don't have the full facts before you in order to, in fact, either be a party in full force and ask for the recusal or do anything because there's allegations and those allegations are not really met.
But when those allegations dealt with by Advocate Semenya SC?
No, Justice Matopo, they were not. In fact, if I can then take the court to particular portions of what is asked at particular times.
But I recall reading the papers that allegations were made that Advocate Semenya SC was at some point involved with the NPA in some capacity of some sort, advisory role or whatever.
Oh, no, Justice Matopo, I think there needs to be an explanation of this. I think we are actually speaking
I'm
across
confused.
each other. Yes. That is not what the NPA is saying there's been silence on. What the NPA is saying there has been silence on is whether or not when the recusal application against Semenya SC was brought by the NPA, for whatever reasons that recusal was being brought, did the chairperson coach Advocate Semenya? In that, did the chairperson provide Advocate Semenya with cases to utilize in order to answer that application? And secondly, as what is alleged, did the chairperson communicate via WhatsApp to Advocate Semenya on how to attend to particular allegations?
But where would you expect to find that if it's not in the papers?
But these are the questions the NPA was asking directly, because the allegation is made, Justice Matopo,
Well,
by
I
the president.
understand, the allegations were made, and
Yes.
the allegations were made. And at what place or forum would those questions have been answered, or would have been answered?
They were raised in the High Court for starters, Justice Matopo, and they elected to not answer them.
But if you recall, it was common cause, or it has been common cause, that the evidence leader and the chairperson would from time to time interact, speak about the conduct of the case, right?
Yes.
And if you would recall, an allegation was made that by one of the applicants, that the chairperson coached Advocate B.
Yes.
And I pertinently asked the question, does it appear in the papers in what respects those allegations were supported? I don't seem to have any response, except that the counsel for the applicant said allegations were made, there was a denial, and on the basis of Plascon Evans and White for Construction, we should accept the version of the applicant.
Justice Matopo, I'm not sure there's a complete denial, if we're being honest here.
No, it's not whether you accept whether there is or not. It's whether the principles relating to motion proceedings, what do they tell us? And we would have, at the end of the day, when you consider all the papers, decide whether indeed there was or there wasn't. Allegations were put forward, and what was the response? And on the application of Plascon Evans rules, what is the conclusion that we must arrive at?
Justice Matopo, I think I need to take the court to the particular allegations that are made by President Zuma, and then the responses that you get from the commission, which is what necessitated the NPA saying, well, you have a duty of candor. You need to answer these directly. Did it happen or did it not happen? It's a simple yes or no answer, and this is where it happened. This is basically what
Maybe
the NPA says.
I don't understand the role of the NPA in these proceedings.
Well, that might be.
Are you saying what the first applicant is saying about the duty of candor? If what you are saying is what has been said by the applicant, shouldn't we follow the submission by the applicant to say whether what has been put forward before us to make a determination, we should make a determination in line with that submission? Or is your submission different from them?
Thank you, Justice Matopo. It's not entirely different. In fact, the submission in relation to candor has always been the submission of the NPA. That's the starting point. That's common cause. It has always been the NPA that says there is a duty of candor that arises in these particular allegations. The position of the NPA in this court is that it has decided to abide. But in making that decision, it's asking the court that when you make the decision, also have regard to the rights of the parties that are not party to this fight between the applicants and the commission. More so in relation to what it would mean if the allegations that are alleged against the chairperson and the chief evidence leader are true. That's all the NPA, in fact, is saying. And then saying, because of that, because of the lack of candor, there are issues that the NPA cannot even deal with. And therefore,
so what instruments would assist us in answering that question? I mean, in terms of the pleadings now, what would assist us in answering that question?
Unfortunately, the long and short answer, Justice Matopo, would be a full Rule 54 record, which is what a full Rule 54 record, which 53, sorry, it's been a long day. It's a full Rule 53 record, which is what we even before the court. In fact, the first applicant, Mr. Zuma, President Zuma indicates that we, in fact, even at the High Court, the NPA, when I say we, indicated why it was prejudicial not to have the full record, because the full record would then have determined what our rights and obligations are. If it turns out that there's no truth to this allegations, the NPA is not a party, it just backs off. But if it does, then let's play this out. If you file the full Rule 53 record, and the Rule 53 record shows that these emails and these alleged, let me use alleged, these alleged emails and SMSs exist, you can then accept that they directly affect the NPA's rights, because the NPA was the party that had brought that application.
Can I please interrupt you?
Yes, Justice Mathopo.
For the purpose of this hearing,
Yes.
if we were to be attracted to the proposition that you are advancing, what would you want or prefer our order to include? Because you're talking about the Rule 53 records, but I just want to know, at the end of the day, if you are the NPA, what would you want the order to include?
This is the beauty of where we sit. We haven't asked for particular relief. We've just asked that the court have regard to the fact that if the Rule 53, let's now deal with the different scenarios, Justice Mathopo. They say this court decides for the applicants on the rule, on the section 47. And as I said, we make no comments on that. And then you get to the review itself. When you get to the review itself, one of the things that this court would have to actually then, in fact, make a finding on is whether or not that record is complete. And as things currently stand, the NPA does not know.
Are you saying we would, if there is no Rule 53 record that has been produced, we would not be in a position to make any ruling on the review itself?
If there was no record before you whatsoever?
Yeah, we would not be in a position to make a ruling on the review.
No, that's not what we're saying. I think it's more nuanced than that.
Maybe I should stop.
Well, I think let me just then finish the more nuanced than that. You have a Rule 53 record before you. It's just not complete. My client is abiding because they don't know the full facts. Those would have been facts that they would have known if the record was complete. On the other hand, I cannot speak on what the applicants would want you to do. On the applicant's version, they might well say, and we take no side to it, they might well say, you have enough before you on the record that it stands in order to make a particular decision. What the NPA is saying is that it would have been beneficial for all parties, including the other parties that have decided not to participate here, to have the full record so that we can all then determine how we exercise our Section 34 rights in this particular proceedings. That's all the NPA is saying.
Thank you very much.
Thank you. And I'm not sure, Justice Mathopo, if you want the particular references that my learned friend for the Alada group. Then that's perfect. One would hope. And then that would be our submissions.
Thank you, Ms. Ntloko. Thank you. Do you still insist, Advocate Badlander?
DCJ, can I just give the reference to the record? It's page 004-31.
Do you think we could impose ourselves on you to ask your junior to send us that short little thing that tells us those references?
You mean on the screen?
Yeah.
Yes.
On the screen or in writing? I think in writing.
Well, can we just submit, send after the hearing?
It's not an invitation for further submissions.
No submissions.
It's just those
We'll just
references.
send those one page.
That's fine.
Thank you, Deputy Chief Justice.
Thank you.
Deputy Chief Justice, can we equally then be given that opportunity to just send its references? We will not say absolutely anything. We'll just send you the reference of this is the allegation, this is where it's answered, this is the allegation, this is where it's answered. We are not going to make any submissions whatsoever, and I think that should also be fair for our learned friends, because what they're saying is that we were not they're saying we misled the court because the references say something else.
That's fine.
Thank you.
No submissions, just references.
Just references for both parties.
Thank you. Advocate Mpofu.
Justices, let me just do this really, hopefully. In reply, I just want to deal with what our case is.
It's 10 minutes.
On, yes, thanks.
Yeah.
On the Section 47 issue, because from what I was listening to, it looks like our case, there are certain parts that are not clear. If you go to our heads of argument 006.1.9, and I'm addressing now Justice Rogers' points, one of which he said was not raised, is raised here. But secondly, I agree, just in case I forget, I agree with Justice Rogers' approach on the question of direct appeal. And that is vindicated by, if you look at page 1 of all these big documents, the very first page, you'll see that there is our notice of application for leave to come here. It says exactly, it deals with what Justice Rogers was talking about, which is, firstly, it says notice of urgent application for direct leave to appeal in terms of Rule 19. So that's what it is. And then it says, read with Rules 12 and or 18. In other words, the question of direct access may just be surplusage. But if you go to page 2, you'll see the reply covers what Justice Rogers was talking about, where one of the prayers we want to say, granting us leave to appeal for upholding the appeal itself and granting the relief sought. So that covers, we agree that it may not be necessary to even deal with Rule 18 per se. But the issue that is raised by Justice Rogers about the expression, one of the honorable justices, I can't remember, I think it was Justice Dambuza, and I made this note, thank God Justice Rogers then came to the rescue. Because what was being said is that the section talks about any judge, and therefore it's wide. But that's, the point is made very clear. The expression we talk about is not any judge. It says, this court, this is what I'm reading now, paragraph 15 of our heads. This court is called to answer the following crucial and separate interpretational questions. 1, first, does the expression any judge of a superior court, as it is, as used in the section, include retired judges? And that's Justice Rogers' point. I don't need to develop it. So is the expression any judge of a superior court, because any judge could mean any judge, but I don't need to repeat what was said. So that's the first one. The second one, we say, in the case of retired judges, does the court accord interpretation of the phrase, the head of that court? Because those two goes together. Any judge of a superior court and the head of that court both fit in snugly with what Justice Rogers was, the point he was making. And then we say third, does the section apply when a judge, whether active or retired, is specifically cited nomine officio, which is a separate point. And let me just pause here. One of the reasons, and I can't remember which justice, I'm just rushing for time, about not having to go to the SCA is exactly this point, that the Mantashe case, we've made this point, we can't just go and join that case, because that case deals with a narrower issue. It doesn't deal with all the issues that are raised in this matter, which are retirement, citation, this issue of a superior court, the civil proceedings, and so on. So even if you join that court, we would just be cutting ourselves in the foot, because it's them who should be joining this case and deal with their portion, not the other way around. And then fourth, we say, is it contextually permissible to interpret Section 47 by transplanting the definition, that's the cut and paste point that's been made, and I think considered somehow, but just now by Mr. Badlander, that the issue of service is no longer pursuing. And then the fifth, we say the fifth, was it the effect of decision, what is the effect of decisions such as NP versus LP, Corruption Watch, Zuma versus Secretary for State Capture, and so on. I've made those points. That's the point about Mlambo JP, because if you're Mlambo JP and Menenga JP, if you are saying, as one of the defenses that has been offered here, a judge is a judge, then you are saying both Mlambo JP and Menenga JP are wrong, because both of those judges have said explicitly that the section applies to retired judges only when they are recalled to perform judicial functions. But a judge is a judge means even if they're just sitting somewhere there, it covers them. Nobody can argue that seriously. And then we say, and Justice Tabuza, I think, made this point. The distinction in 1762 cannot be wished away. Because if you say a judge is a judge, it means you're saying that distinction means nothing between active service and the holding of office until the end of that. And then we then deal with the thing about civil proceedings by way of notice of motion. We've dealt with that. And then the eighth, we say finally, Section 47, truly a jurisdictional provision. The importance of that is that, remember, the alleged mootness of our Rule 53 1B application, which Ms. Nkoko is correct about, has never been answered, never been answered. Talk about candor and every scrap of paper. The mootness, the alleged mootness is because of the mistake that takes Section 47 as a jurisdictional point. Because it says, well, if you don't have jurisdiction, we don't even have to give you anything, candor or no candor. But that's incorrect. The next point is, okay, the most important point is Justice Rogers' point about what he called the more mundane purpose. We had said earlier, I think something the less loftier purpose. But that's the point, because the confusion here seems to be made between this section being this bulwark and protector of judicial independence and what have you, whereas the section is simply to do what the judge president said it was to do, which is to regulate the courts. Well, justice delayed is justice denied is the other defense. Well, we say justice cuts both ways, I'm afraid. So which justice, what justice can emanate from a commission that is tainted by bias in all the various ways that I have? What justice for the victims, what justice for our clients? Zero, as we said. So whether it's delayed or whatever, the only thing that can happen is to put good money after bad money and spend more millions on something that, as we said, is doomed to fail. Very quickly, Justice Matopo, on the issue of Ramakatsa. We say not Ramakatsa, the Zuma case. This court had said that that case was urgent and required direct access. That I'm talking about the Zuma case. And on the basis, one of the reasons cited was that a former president of all people is of all the things that were said there. Now we say here the jeopardy is double of that, because there are two former presidents who are in danger of being forced into an illegal gathering. Now, then there's the issue about, I think it was Justice Theron, or it was raised by one of my learned friends as well, that where the Justice Khampepe says that I'm not performing a judicial function, that it was her opinion. But that's the point we're making. It was her opinion that she's not performing a judicial function, but her opinion today is that she is. That's what's wrong with this picture. And then the issue about temporary boundary, Justice Matopo, 100% correct. The 2003 thing is a red herring. 2003 is the point at which it is alleged the interference bore fruit, if you know what I mean. Remember the terms of reference say commission into investigating into the stopping of the prosecutions. So the stopping of the prosecutions may have stopped in 2003, but the interference obviously preceded that. Then, if I may just make these 2 points, Justice. One is there's a case called Dupree versus TRC. I'm not sure if it's on our list. That case is a 1997 AD case, made it plain that the rules of natural justice apply in the TRC, which is a commission of inquiry. Then this is the point that I really want to make. There's a lot of
no, you said that what's the other point?
Okay.
The last one.
Yes.
Yes, what is it?
There's this thing about the HRIU that was raised here. It's another red herring argument. Remember, Justice Theron pointed to the President's affidavit. That paragraph, that affidavit, because I don't have time, I won't go to it, has a paragraph 9. Paragraph 9 has 9.1, 9.2, 9.3, 9.4. Those are the things that the President says, if he had known those things, he would not have appointed. Only one of those things, actually half of them, is the HRIU, because the other one is that she worked at the Amnesty Commission. But on top of that, we've given a list in our affidavit of other TRC commissioners who, like Ms. Suka and Advocate Ntsabeza and so on, who are called as witnesses. So let's say for a minute, and Mr. Manesha will address
that's the
this.
point, isn't it? That's the point. You've made the point.
Well, I haven't made the point.
No, you've made it. You want to go further than you were asked to do.
Yes. Okay. The other point about Justice Nuku's issue about what should happen, assuming what we are only dealing with is the failure. Well, Section 6.2G of PAJA covers that, because it says what is reviewable is not only the administrative action that's positive. The failure to take action is also on its own right reviewable.
Thank you, Advocate Prof. Thank you very much. Thank you.
Please give me half a minute.
Thank you very much.
I promise, half a minute. And the point is this, and this deals with also Justice Dambuza's point, I'm sorry, that, and someone else said this, the protection of judges against vexatious litigation outside of this scope is the same as all of us. We're all protected against vexatious litigation by the Vexatious Litigation Act, abuse of court, and so on. So there's nothing that should be extra protection outside, as Justice Theron puts it.
Thank you.
Beyond the ambit of this section. Thank you. I'm going to take it.
Thank you very much, Advocate Mpofu.
Thank you,
Please go ahead when you're ready, Advocate Manager.
Yes. The first point I want to deal with is and I have great respect for my learned friend, Mr. Badlender, and I believe he didn't deliberately misconstrue our case, but he misconstrued our case in relation to the role of the chairperson in the NPA. And in the arguments he presented, as well as the argument our learned friend, Ms. Sarah Pudifin-Jones, presented, it underscores the error that the justice made in deciding the recusal application. They both argue that this court must look for an overlap in the questions that the commission must investigate and the questions that the chairperson dealt with when she was in the TRC and the NPA. That is the wrong test. Of course, if there was a complete overlap, she would be disqualified. But that's not the end of the inquiry, and that is what Safu and Bennett emphasizes. You look at whether the subject matter before the commission arises from her prior roles. And I want to show the court what was pleaded on her prior role in the NPA. It is at 011-893-894. Sorry, 001-893 to 894. And that is, you will see there that the allegations about the role in the NPA is dealt with from paragraph 23 to paragraph 34. And there it's set out at paragraph 23, and I'm going to read quickly. Justice Khampepe served as Deputy National Director of Public Prosecutions under Advocate Bulelani Ngcuka from September 98 to December 99. This period coincides with the establishment and operationalization of the human rights of the HI unit. The HI unit's mandate was to review TRC amnesty records, investigate apartheid-era human rights violations, and make recommendations on the prosecution of TRC cases. As appears from the Weber-Wenzel letter, Justice Khampepe played a role in the HIU, including providing advice to the National Director of Public Prosecutions on the approach to TRC matters, and so it goes, and the court will read all of it. That's what it said, is she provided advice. It's not you were a member of the HI unit, full stop. And what is the answer by the commission? You will find the answer at 011-1215. 011-1215, at paragraph 35 specifically, you will see that that allegation is recounted, is never denied, never ever denied, that she advised the National Director when she was, of course, in the office of the National Director under Section 5 of the NPA Act. In paragraph 20 of her own ruling, the chairperson, at 001-269, she says the evidence regarding her prior roles is common cause. So it's common cause what we say there. There's no denial. And in that context, then you look at what Judge Saldanha and Advocate Bulelani Ngcuka have been asked to testify on. The request to Justice Saldanha, the court will find at 011-619. I'm just trying to find, you will see that what is asked to do at 011-336 is paragraph 3. In your capacity as a commanding officer of your particular unit, you have had access to information concerning decisions, discussions, or policies affecting the investigation and prosecution of TRC-related cases. The Commission therefore requests your assistance with furnishing any material in your possession on to which you had access to during your tenure that may be relevant to its inquiry. 5, in addition to providing such relevant material, the Commission requests in the form of an affidavit your own account of any discussions, decisions, or considerations during your tenure that may bear on the matters set out in the above-mentioned paragraphs of the terms of reference. Such a statement will assist in the Commission in understanding the context within which decisions relating to TRC cases were taken. Just Advocate Ngcuka's statement, they didn't include the letter. We've got the letter, but it's not in the record. It's similar to that letter that I just read. But you will see that he recounts what he's asked to do at 011-619. He says, 13, a year later, I was appointed as NDPP 1 August with effect from 1 August 1998. 14, on its 11 October letter, the Commission requests my assistance by furnishing any material in my possession to which I had access during my tenure and request my account of any discussions, decisions, or considerations relevant to the Commission's terms of reference. This is what they're asked to do. These people were serving with Justice Khampepe in the NPA at the same time with the NDPP in his office, because Section 5 says she is. She doesn't dispute. In the High Court, there is a belated denial. At paragraph it's paragraph 243 in the High Court application, 001-493, simply saying, I deny that I was a member of the is you advised, you played a role in relation to TRC cases, which was never disputed and is never disputed. This is a belated denial which is itself unhelpful. In regard to TRC cases that Justice Khampepe decided where amnesty was denied, the extracts from the archives are included in the affidavits. You will find them at 001-327 in relation to the AC 37, 001-336 in relation to the Mutasi family, is part of the Kalata group, 001-339 in relation to the PEPCO 3, is part of the Kalata group. On delay, the question on how you decide delay is set out in paragraph 74 of Bennett, is a question of interest of justice. A party, after full disclosure, is not allowed to wait until an adverse decision to raise recusal, because it would mean if the decision was favorable, there will be no ground for an apprehension. Here, there was no decision adverse to our clients before they brought the application for recusal. They were not participant in the recusal of Advocate Semenya SC, so there was no adverse decision at all, which was the suggestion. In addition, the delay is of 3 months, under 3 months, because in May, there were not interested parties to the commission. You will see the terms of reference identifies the interested parties. The only time they had an obligation to assist the commission and to appear before the commission, in the case of Mr. Mbeki, was when he received the notice 3.3 in September of 2025. So the delay is under 3 months. In Salfu, the delay after full disclosure was over 3 months. You will see that at paragraph 7 of Salfu. In Bennett, after full disclosure, there was a delay until an adverse decision was taken by the SCA. In both of those cases, those judges made full disclosure in order to allay the fears of any bias. In our case, even this court is in the dark about what role did Justice Khampepe play in the NPA in relation to TRC cases. You've been referred to paragraph 78 of the answering affidavit of the commission in the High Court, in the review. You will read those paragraphs. They're all argument. There's no disclosure of facts. It's just argument about why this does not make out a case for review. On the standards of bias as between commissions and the like, my learned friend referred to Dupree, but our learned friend, Mr. Badlender, so rightly, with the respect that we hold him in, that you still have to approach it with an open mind. And complaint about an apprehension of bias goes directly to an absence of an open mind. So we agree with him. On Rodriguez, yes, Rodriguez has made scathing findings against the executive without hearing them. That is why you have a commission of inquiry. If Rodriguez was binding about the executive interference, you would not have a commission of inquiry. That would be carried quaestio, if that is the correct expression. Then there is a suggestion that the arrangement about the hearing of evidence was all dealt with and it covered all parties. You will read the account properly in the affidavits. The secret arrangement between the Kalata Group's counsel and the chief evidence leader was only disclosed at a pre-hearing meeting. All the parties objected. It resulted in written submissions, argument. All the chairperson did was to endorse that arrangement. And in the meantime, Advocate Semenya was told not to interview NPA witnesses. He did. And she didn't reprimand him when endorsing all of that and finding that his recusal must fail. So we submit with respect. And on the section 47, and that's my last point, there is no answer to the contextual reading of the section which the bench has put up, especially Justice Rogers and the other justices of the court. And we are really indebted to that insight which we may not have picked up to assist the court in making a proper determination on section 47. We submit on all the circumstances that this appeal should succeed in all respects and the review should be determined in our client's favor. We ask costs, but that's in the court's discretion. Those are our submissions, and are truly, truly indebted to the court to have extended its time until this time of the day. as the court pleases.
Thank you very much, Advocate Manager.
Deputy Chief Justice, I'll say nothing about the NPA or anything about this case at all, I promise. We've been informed that this is the last matter in which Justice Majid will be sitting as a member of this court. And I've been authorized by my senior, sitting over there, to make some remarks about it. He says I may not be senior, but I'm older. That's what he says. It's going to be a great loss, not just to the court, but to all of us, Justice Majid, when you leave. I think we've all appreciated your sharp insights. We've appreciated your passion for justice, and particularly your passion for those who sometimes can't speak for themselves. And we've appreciated your passion for the transformative goals and transformative ideals of the Constitution. We know you've written judgments about that. We know you've spoken about it extracurrially. And we all greatly have valued and appreciated that. I think we all have also greatly valued and appreciated the way you have managed us in court. You've done so always with courtesy and firmness, and often with a spark of wit, which has greatly solved some difficult situations. So I'm sure I speak on behalf of all of us when I say that we thank you for your service to the court and to the country, and we wish you a very lengthy and very happy and very fruitful retirement. Thank you.
Thank you very much, Advocate Badlander, for those sentiments expressed about our brother. As he says, the proper time when all that we want to say will come at the end of the year. But thank you very much for recognizing that. We recognize it. We will also miss him. We tried our best to twist his arm not to go, but he's going. That said, this brings us to the end of today's proceedings, and the court adjourns. Judgment is reserved.